Yeah, I'm honored to introduce Dean Suagee, and when we're putting this dialogue together, I looked around from the experience of our work as Indigenous people in protecting the sacredness of our Mother Earth, the environment. And Dean has always been that person, that attorney that I look towards to give me some advice, because he has that long history working with tribal nations on environmental protection, but also the conservation and protection of our historical properties, our sacred sites. And just a real quick, Dean is an enrolled member of the Cherokee Nation of Oklahoma, and he's been able to work as an attorney and practice Indian law by his knowledge of history, awareness of damage being inflicted on the natural world, and a basic sense of justice. He specializes in environmental and natural resource law and cultural heritage preservation. And he joined Hobbs and Strauss, a law firm, in 1988 as an associate, and has been with them. He has a long history in what we call indigenous territories to build environmental and cultural resource regulatory programs. And he's also carried many positions in developing environmental policy acts. He's an excellent writer, and he has many different positions. I can go on and on for about another 10 minutes on his bio, but I'm proud to introduce him. Dean, here you go. We just used your time up. Dean.
Thanks, Tom. Let's see. Clayton, you got my PowerPoints? Okay. It's a real honor. Let's see, does this work if I put it in the... Does that work like that?
Yes. Okay.
It's a real honor and a privilege to be here. People were telling their Haskell stories. My late father, J. Tennyson Suagee, is an honorary alumnus of Haskell. In the late 30s, he lived on campus and had employment on the Haskell campus while he was attending classes at the University of Kansas across town. He subsequently got financial aid through the government and went and transferred to the University of Oklahoma, which is where he got a bachelor's degree and a master's degree, and also where he met my mother, which is a good thing for me. Are we going to have to move that tape? I think we're going to have to move it. Maybe we need the lights lowered too.
Get the spotlight off, we'll raise something back.
Let's see. That's good. Yeah, thank you. And Clayton, are you operating the? So we got. Tom had asked me to weave together several different topics. Federal Indian law, environmental law, cultural heritage, and the rights of Mother Earth. Any of these subjects, well, the first couple of subjects, federal Indian law and environmental law, are subjects which are treated in numerous semester-length courses. So I'm only going to, briefly touch on some of the themes. Try to weave together what's particularly relevant for this conference. I decided to start with federal Indian law because just seems to flow into better. So go to the next slide. We're still working on the lights. I've included this map of Indian country because federal Indian law is the law that, the body of law that governs Indian lands. And I think most people in this audience know where Indian country is, where where reservations are. I just like to have some graphics with the presentations, so I'm not just words on paper. But let's go to the next slide. Federal Indian law is a complicated body of law. It's really, in some ways, it really only makes sense when you understand it in historical context. And to understand it in historical context, you really have to know something about the historical eras of federal Indian policy. In the early days when the Indian nations on the East Coast held a fair amount of military power, there was bargains between relative equals, which soon gave way to treaties which were primarily land transactions, in which tribes gave up vast amounts of land in exchange for, and the key thing here is in exchange for the promise of the federal government to protect the tribe's right to maintain the land that it had not given up, the land that as a place for a separate homeland where a tribe could maintain its distinct culture. Toward the end of the 19th century, we passed into a diabolical era of federal Indian policy, commonly known as the allotment era, when commonly held tribal lands were divided up among individual and assigned to individuals, with the intent to essentially force Indian people to give up their culture, their cultural values, and become like white people. Generally recognized as a disaster, was abandoned in 1934 in the Indian Reorganization Act, which held sway. I mean, the Indian Reorganization Act is still, in some ways, the foundation for modern Indian law, but we passed through this dark period of the termination era. I was just spooked by the feedback there. Maybe I'm just too close to the mic. So we're currently in the Indian self-determination era, which gets its name from the Self-Determination Act of 1975, which set the framework for tribes as governments to take over federal programs previously run by the Bureau of Indian Affairs and the Indian Health Service. Click it once. But while we have this policy of self-determination, we've also seen the rise of a doctrine that's come to be known as judicial divestiture, or the loss of aspects of Indian tribal sovereignty through decisions by the courts, primarily by the Supreme Court. There are, and so in the last 3 decades or so, the Supreme Court has undone some of the foundation principles of Indian law, but I think the foundation principles are still a valid place to get a grasp on the subject matter, and I view this as 4 interrelated principles. And any one of these principles we could spend hours talking about, but you have the doctrine of inherent tribal sovereignty, which is in essence that the governmental powers of an Indian tribe are not given to it by the national government, but are inherent in the tribe itself. We have the doctrine of the trust responsibility, which is a double-edged sword, to be sure. In some senses, it arises from the assertion by the federal government that the government holds legal title to Indian land, while the tribes have the beneficial title, the right to use and make use of the land, to possess it. But the federal government claims a residual underlying fee, which puts the federal government in the position of a trustee. The federal government also has responsibilities for managing for some of the returns that are generated through economic activities on Indian land. Am I really close to the mic, she says. But it spooked me before when I got feedback, but oh well, we'll try. All right. It's important, the trust responsibility is one important beneficial aspect of the trust responsibility is that many of the conflicts that tribes have gotten into over the decades, many of the conflicts in the tribes asserting their governmental authority or resisting governmental authority are not conflicts between the federal government and tribes, but rather are conflicts between the tribes and states. And one beneficial aspect of the trust responsibility is that the states have sovereign immunity and tribes can't sue states, but the federal government can sue states. So in many of the leading Supreme Court cases that there are conflicts between tribes and states, it's actually the federal government litigating the case representing the interests of tribes. Then we have this doctrine known as reserved rights. That essentially means that when a tribe entered a treaty with the United States, the tribe gave up certain things that are specified in the treaty. Everything that the tribe did not give up, it reserved to itself. So you have hunting and fishing rights on reservations where the treaty says nothing about hunting and fishing rights because the tribe didn't give them up. The concept of reserved rights also applies to executive order reservations. One of the places where you see this prominently is water rights, the doctrine of federally reserved Indian water rights in the West. Then we have this doctrine called the plenary power of Congress, which is another double-edged sword. One of the ways that this, while we like to, we tend to think about the plenary power of Congress in negative terms. But one of the positive spins on that is that Congress does have authority to enact legislation that is beneficial to tribes. Congress does have the authority to resolve jurisdictional issues, disputes between tribes and states, and clarify the limits of state authority within reservations and the extent of tribal authority. And there are a number of examples where Congress has used its power to benefit tribes in that way. We have canons of construction, which I won't talk about, and this basic principle that the plenary power of Congress can be seen as a manifestation of the power of the federal government vis-a-vis the states. The federal government is assumed to have, in terms of American constitutional law, the federal government is said to have enumerated powers. The states have inherent sovereignty. The states are envisioned as having created the federal government, giving it supreme power in certain enumerated areas, and in the authority to regulate the dealings with Indian tribes is one of the enumerated powers of the federal government. There's just some citations. I use these slides for presentations in law schools, and these are some really important law review articles. But and this is a cite to one of my articles, the Supreme Court's whack-a-mole game theory in federal Indian law. And I'm going to go through a little bit of whack-a-mole game theory. On the doctrine of inherent sovereignty, up until 1978. The basic notion was that tribes could lose aspects of their inherent sovereignty either by giving them up in treaties or by having them taken away through specific acts of Congress. But if tribes had not lost aspects of their inherent sovereignty, they still existed. But in Oliphant versus the Squamish Indian tribe, in order to find that tribes lack criminal jurisdiction over non-Indians, the Supreme Court essentially made up a new rule which holds that tribes can lose aspects of their inherent sovereignty by implication. Now, I'm going to run through these next slides pretty quickly because I really don't want to be the person standing between everyone else and lunch, and we're already behind schedule. And I've got some other slides getting through. But the essence of the whack-a-mole game theory is that in 1981, the Supreme Court extended this limitation, the doctrine of implicit divestiture, to the civil regulatory context. But acknowledging that there were already a number of Supreme Court decisions which had upheld tribal civil authority over non-Indians, they fashioned those cases together into what they referred to as two exceptions, that tribes may regulate the conduct of non-Indians when there are consensual relations, or when the conduct that they're seeking to regulate threatens the political integrity, the economic security, or the health and welfare of the tribe. Go to the next one. This is a slide that goes into the logic of the Supreme Court's decision, but we'll skip through that. And skip this one. Whack-a-mole game theory is that these exceptions never apply. Basically, Indian tribes and their lawyers are the moles in this game, and we look up at the game board and see these holes that represent the two exceptions to the Montana principle and say, we fit exception number one, and the Supreme Court says, no, you don't. Or we say, we fit exception number two, and the Supreme Court says, whack, no, you don't. And there's a line of cases bearing this out. And I could take an hour talking about each of these cases, but I won't. Right, I won't today. But moving on to the second set of topics for this talk, in environmental law. I wanted to, build up to the explanation of what tribal governments can do within our frame of environmental law. But as our earlier speaker mentioned, environmental protection law has a strange history, and I want to shed a little bit of light on it. Part of this comes from property law. Some of the roots of environmental law can be found in property law, and this concept, the concept of that a landowner has the right to use his or her property for beneficial uses, to the extent that, as long as it doesn't interfere with the rights of neighboring landowners to make use of their property. This notion that that the land can be owned, and the limits of your rights to make use of the land are, when the basic concept is your rights to make use of your land are limited by the possibility that you're going to impair the rights of your neighbors to make use of their land. That basic concept in English and American common law is known as a private nuisance law. That's kind of the background for a source of inherent state authority that's commonly known as the police power, which is the power of the states and there's political subdivisions, local governments, to enact legislation to protect the public health, welfare, and safety. Under the U.S. Constitution, that's an aspect of state sovereignty. Go to the next one. Then so this notion under the U.S. Constitution, it states that have the power to enact laws to protect the environment. But in the 1960s, it became apparent that that was simply not adequate. And I'm old enough to remember some of those impacts. I remember dead fish floating in the Potomac River. Well, some of that's happened more recently than that, but the Cuyahoga River catching on fire, memorialized in a classic song by Randy Newman. But it became apparent that controlling pollution was something that required a national approach. But when Congress enacted national laws, they did so in a way that fit within the constitutional framework that preserved the authority of states to perform prominent roles in that legislation. And because the national government is a government of enumerated powers, there has to be a basis for the federal government enacting environmental laws. And the two principal constitutional clauses are the Commerce Clause. So much of environmental law is tied to interstate commerce. And then there's also the Spending Clause, in which the federal government helped the states create environmental regulatory programs, and by providing substantial amounts of funding to state environmental regulatory programs, the federal government has the authority to put conditions on the way the states spend the money. So I wanted to mention the first generation of national environmental laws, which might be said to begin on January 1st, 1970, with the signing of the National Environmental Policy Act, which is a law governing federal agency action. It's a procedural law governing the ways federal agencies make decisions. Then we have the Pollution Control Acts, which put limits on the amount of pollution that can be lawfully emitted into the environment. The Clean Air Act of 1970, there was a predecessor statute, but the 1970 version made this regulatory. In 1972, the Clean Water Act. In 1976, the Resource Conservation and Recovery Act, an amendment to the Solid Waste Disposal Act, are the three main federal environmental regulatory statutes. The Endangered Species Act, 1973, is in some senses regulatory and in some senses a review requirement that typically gets plugged into the NEPA process. And then in 1980, we have a different kind of environmental law, the Comprehensive Environmental Response Liability and Compensation Act, commonly known as Superfund, which was enacted to clean up contaminated properties. Now, if you think about that first generation of federal environmental laws, I hope that's not my 5-minute warning already. Okay, all right, I'll try to talk faster. When Congress enacted that first generation of environmental laws, if you think about that and put it next to the eras of federal Indian policy, that was just the beginning of the self-determination era. We were just coming out of the termination era. Congress and the congressional staff did not give much thought to what roles Indian tribes as governments might play in carrying out the federal laws. In the mid-1980s, Congress enacted some amendments to correct that, beginning in 1986 with amendments to Superfund and the Safe Drinking Water Act, and then in 87 with amendments to the Clean Water Act, and in 90 with amendments to the Clean Air Act. All of these authorizing the Environmental Protection Agency to treat tribes like states. And being treated like a state is a big deal in federal environmental law because, as I mentioned earlier, states have real power. States carry substantial responsibilities for the implementation of federal law. They establish a lot of the policies. They do most of the enforcement. So the idea that tribes could be treated like states is a substantial improvement and a recognition that tribes have. I believe this is a recognition that tribes have inherent sovereignty over the subject matter of environmental protection. Go to the next one. Just for one example of the various ways that the Federal Environmental Pollution Control Acts work, this is a real simplified notion, but the Clean Water Act has many facets to it. One part of it is the establishment of water quality standards, which basically said, the level of pollution that is permissible within particular water bodies. And within the Clean Water Act, the role it is, the establishment of water quality standards is assigned to the states. There are no federal minimum water quality standards. There are federal guidelines, and the standards that states adopt have to be approved by EPA, and then they get the force of law. But it's states that do this in the first place. The principal regulatory mechanism of the Clean Water Act is point source permits under Section 402, also called the Nepenthes Permit Program, a National Pollutant Discharge Elimination System. And that's a program that's run by the federal government in the first place, but can be delegated to the states, and most of the states have delegated authority to run the Nepenthes Permit Program. Section 401 is certification. When EPA issues a permit for a point source, the state has authority to certify whether or not that permit complies with its water quality standards. So the state where the receiving waters are essentially has the authority to veto the issuance of a permit by withholding certification. Of course, it has to be on reasonable grounds. All of these things are things that Indian tribes can now do, although there are only about 30 some odd tribes that have approved water quality standards, and as far as I know, I believe there's only one that has a Nepenthes permit program. There's a lot to running these programs, and part of the problem is the lack of resources, the lack of a tax base for tribes, the lack of access to technical expertise. But I think the biggest impediment is the threat of litigation flowing out of the Supreme Court's case law, that if the tribe asserts regulatory jurisdiction over non-Indians, it can expect to be sued and have to defend its actions in court. To move on to this topic of cultural resources, there's a pretty extensive body of federal law that recognizes tribal rights in their cultural heritage. And I also here have some quotes from the UN Declaration of the Rights of Indigenous Peoples. But just hold this for a second. I just had to throw in a picture. This is in Northwest Arizona. I do a lot of work for the Hualapai tribe in Arizona, and this is a place that's outside their reservation boundary. It's within their Aboriginal territory and has a lot of significance. It's a place where there were a number of different bands of the tribe. This is a place that they came together to gather resources. And there are a lot of stories that are tied up to it. This is also an area where a massive solar energy project was proposed a couple of years ago, which ultimately hasn't been built, but developers have their eyes on this area. Probably the most important federal statute for tribes protecting their cultural heritage is the National Historic Preservation Act, But I want to move through this really quickly, so we won't talk about this. I've got too many slides because I saw my 5-minute warning, and I want to get to the rights of Mother Earth. The National Historic Preservation Act is intended to protect places that are eligible for the National Register of Historic Places, and is specifically acknowledges that places that hold religious and cultural importance for Indian tribes may be eligible for the National Register, and if they are, and a proposed federal action would affect a place that's a historic property that holds religious and cultural importance for a tribe, the tribe has a statutory right to be a consulting party in the review process. This is a procedural right, but it's a procedural right that applies regardless of where the property is. It's on and off reservation. It's not just tribal lands. The Act, the 92 Amendments, also authorize tribes to establish tribal historic preservation officers so that they have staff in place to deal with some of these issues. Let's slip through the next set of slides. I'll tell you when to stop. I was going to talk about NAGPRA, but I won't. Let's back up just to hit that one. Just the ERFA, the one more forward. It's important to remember that there was a long period when the federal government affirmatively tried to stamp out Indian religions. It's only since that policy was ended in 1934, but it's really only 1978 when you have an affirmative policy supporting tribal religion. It hasn't done much good. The Supreme Court has ruled that the First Amendment doesn't really apply to Indian religions. Let's go to the next slide. Let's move on to one more. I just wanted to call your attention to a few of the articles in the UN Declaration on the Rights of Indigenous Peoples, because there are several of these articles that are specific to cultural heritage. But I'm not going to. Let's move through them quickly. Article 3, part of the right to self-determination is the right to determine cultural development. Article 11, the right to practice and revitalize cultural traditions and customs. The right to manifest, practice, develop, teach their spiritual and religious traditions. The right to revitalize, use, develop, and transmit their histories, languages, and traditional philosophies. The right to dignity and diversity of cultures, traditions, histories, and aspirations. And the right to traditional medicines. There are other articles that are also relevant, but these seem to be the key ones to cultural traditions. And I think these are also relevant to to notions of how tribes, both as governments and as cultures, fit into the concept of the rights of Mother Earth. So let's go to rights of Mother Earth. In thinking about this, I looked at some of the provisions in the Declaration on the Rights of Mother Earth, and came up with a few questions that I think are worth noting. Just as human beings have rights, all other beings have rights which are specific to their species or kind and appropriate for their role and function within the communities with which they exist. So the question is, how do we define and articulate such rights? What about communities that have been created by people? What are the rights of animals and plants in those communities? And then I thought, I was looking at this book of the National Museum of the American Indian exhibition called A Song for the Horse Nation. And I thought, is one of the roles of a porcupine to give up its life so that a human being can work its quills into a decorative mask for a horse? Which I think is one specific question that could be raised by that. The rights of each being are limited by the rights of other beings, and any conflict between them must be resolved in ways that maintain the integrity, balance, and health of Mother Earth. How do we define and articulate the limits? Who resolves conflicts? I think these are real challenging questions. Governments, peoples, communities are supposed to establish and apply effective norms for the defense, protection, and conservation of the rights of Mother Earth. What can and should tribes do as governments? Is another question. And we guarantee that the rights and that the damages caused by human violations are rectified and those responsible are held accountable. What about those people that are accountable that are long gone? And then this recurrent question: what can and should tribes do as governments? I think I've got one more. Promote economic systems that are in harmony with Mother Earth and in accordance with the rights recognized in this declaration. What can and should tribes do as governments? I think those key questions. And I've got a couple graphic slides on what tribes can and should do as governments. And this gets us back to the issue of climate change. This is the concept of stabilization wedges, for recognizing that there is no single solution to reducing greenhouse gases, but there are combinations of solutions. If you go to the next one, this is a graphic from a study conducted by commissioned by the American Solar Energy Society about 5 years ago, which shows the potential for energy efficiency and various renewable energy technologies for reducing greenhouse gases. And they basically concluded that, well, the biggest chunk is energy efficiency. Energy efficiency alone can bring us down below where the curve is flat, and the various renewable technologies can bring us down on a target, on a trajectory to meet the required emissions reductions to avoid the more catastrophic impacts. This is a slide that shows that there are different ways of breaking down carbon emissions. This is a slide that I got from an organization called Architecture 2030, and they point out that the biggest chunk of emissions are associated with buildings. And we know how to make buildings consume zero energy, make them net zero fossil fuel. And I think this is one of the biggest things that tribes as governments could do would be to promote zero energy buildings as a standard. And then my last graphic, this is what a mix of energy sources that would look like if sustainability was the goal. This graph was prepared by Dr. Doug Balcom, who many years ago he worked for Los Alamos National Laboratory for a long time. He developed the basic methodology for analyzing passive solar design principles in buildings. I used this at an energy conference once, and someone said, "Boy, he doesn't think much of nuclear." And I forgot to look. And after that, I looked up and I saw that, well, his PhD is actually from 1958 from MIT in nuclear engineering. So it's not that he doesn't like it; it's that he understands it and doesn't like it. So thank you all very much. And I hope some of those questions will be useful fodder for the sessions that follow. Thanks again.
Thank you very much, Dean Suagee. So we have facilitators who are taking notes. I noticed that they were really busy taking those questions down. One of the questions that are being asked by some of our Indigenous governmental leaders, as well as the United States, who put this question out when Bolivia brought it up at the United Nations General Assembly, is, would there be a conflict on right to development? One of the articles in the Declaration of Rights of Indigenous Peoples is right to development. So that I know that some of the questions emerging from some of our large native nations who are embrace some of the Western forms of development for economic development.